Give me just a second. Looks like we're on, are we doing the same on both of these?
Same on both.
Okay, let me,
If we may, Judge, with the court's permission, go on the lesser included offense of a terroristic threat of a public servant.
yes.
That offer was made based on a couple of facts, obviously taking into consideration that he has now been found competent. If the court would take judicial notice of that, I think that played into the offenses themselves, the fact that he was previously incompetent and now has received treatment, as well as his medical condition. The court has also given me time at a past setting to make inquiry as to the status of his lawsuit against the jail. I have done that on multiple occasions with our civil division, and it's my understanding that there is nothing pending.
Okay, thank you very much, Ms. Malfino. All right, sir, you're Edward Sellers.
Yes, ma'am.
And I'm going to take judicial notice of the court's file in each of the cases, and that specifically that Mr. Sellers was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I received a report November 25th, 2024 from that facility. That was done by Dr. Stephen Coates, and it is his opinion in that report that Mr. Sellers had regained a competency and that he was currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from state.
Excuse me. Then at this time, based on those reports, if I haven't already in a prior hearing, I am going to find that Mr. Sellers is currently competent to stand trial. All right, and will he waive the formal reading of the indictment in each case?
He does.
Mr. Sellers, in cause number 24 DCCR 0386, the state has elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat of a public servant. That's from December 19th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And then, all right, give me just a second to make the proper notations before I... Yep, thank you. No, you should ask. I keep doing this wrong. Terroristic threat of public servant. Okay, now, and cause number 24 DCCR 1927, the state is also elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat of a public servant. And that is from August 5th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Okay. Yes, ma'am.
So if I follow the agreement, you can't change your mind later and appeal. You understand?
Right.
Your signature's not on one of them. And are you a U.S. citizen, sir?
Yes, ma'am.
State tenders number 1 in each case?
No objection, Judge.
It's admitted in each case. All right, Mr. Sellers, in each of your cases, I'm again finding that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of these pleas.
Okay, pause right here. Things are about to get official. The judge is checking the paperwork, and that little give me a second moment, that's the calm before the legal storm.
In cause number 24 DCCR 0386, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of harassment by a person in a correctional facility. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1927, also find that you entered your plea of guilty freely and voluntarily. find that you're mentally competent, understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor terroristic threat of a public, I said it wrong in the one previously, I'm sorry. In each of these cases, you are found guilty of the Class A misdemeanor terroristic threat of a public servant, and then sentenced to 1 year in the Jefferson County Jail. These sentences will run concurrently, which means together at the same time. And did I print the second one? Not yet. Okay. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. All right. Good luck to you, sir. Thank you, Mr. Lewis, Ms. Malfino. Okay, let me get this pulled up. All right, so this is cause number 21-36906. I'm going to take judicial notice of the court's file. Mr. Wilson was previously found not competent to stand trial, was sent to the North Texas State Hospital Vernon campus for competency restoration. I received a report from them dated January 16th of 2025 that made the finding that Mr. Wilson had achieved competency and was currently competent to stand trial. That report was from Dr. David Mills. Is there any other evidence with regard to competency?
No, Your Honor.
No.
All right, then at this time, based on that, I will find that Mr. Wilson is competent to stand trial. Ms. Perazo, will he waive the formal reading of the indictment?
He will, Your Honor.
And are we going on both counts?
I believe so, because it's within the range of punishment.
Gotcha. Well,
With a cap of 5, I don't think.
you need to do the second, otherwise it's, otherwise it's 5. Because that would be the, if it's the first
Okay.
degree. So
Okay.
so count one only?
one.
Count.
Yes.
Let me just-
I apologize.
That's all right. Let me just get this pulled up so I can do it properly. Mr. Wilson, the state has elected to proceed on count one only. That count,
Now this part is huge competency restoration, means the defendant was once not mentally fit to stand trial, but after treatment the court says he's ready, basically therapy before testimony.
alleges that you committed the second-degree felony offense of aggravated assault November 4th of 2020. And how do you plead to that charge?
Not guilty.
Okay, so do you want, it's my understanding that you were going to enter a plea of either no contest or guilty so that we would go forward with an agreement that you have. Is that not what you want to do?
I told him no contest.
Okay, so you talked to Ms. Perazo about your case, right? And what I see here on the paperwork is that the agreement is that you would be leaving your punishment up to me if we go forward today. And that would be for a cap of 5 years, which means I can sentence you to 2 years, 3 years, 4 years, 5 years. I can consider probation. Will depend on all the information that's given to me at a later hearing date. But if you're, in order to go forward with this, it's either a plea of guilty or no contest. If you plead not guilty, then we have a jury trial, and if they find you guilty, then they sentence you anywhere in the range of punishment. Do you understand? So what do you want to do today?
Want to fight this charge?
You want to fight the charge?
So you don't want to plead no contest?
5 years. That's just for nothing.
I'm sorry?
No, I was just telling him 5 years, just taking probation. That's really for nothing.
Okay, that's completely different than what you just told me. So,
I'm still thinking on this, though.
Well, here's the thing, Mr. Wilson, listen real carefully, okay? Because I want to make sure you understand. Nobody's trying to talk you into anything today, but we want you to understand what your possible consequences are if you go to trial and what your options are today. Ms. Peraza, hang on. Mr. Powell, listen real carefully, okay? Don't talk over me. Let me talk, and then if you have something to say, I'll ask you about that, okay? So I know Ms. Peraza has met with you and gone over everything. She has reviewed all of the evidence in the case, and so I advise you to listen to her. However, the decision is yours on what you want to do. So because you have a prior burglary of a habitation conviction back from 2011, if you go to trial on this case and a jury finds you guilty, the range of punishment changes from a second-degree felony to a first-degree felony. And that jury could sentence you a minimum 5 years up to the rest of your life in prison. So do you understand what could happen and the consequences are if you go to trial?
If I'm get that, I know they're gonna give me lifetime.
Well, I just want to make sure you understand that they could give you anywhere in that range of punishment, right? You understand that? And so today, what y'all have talked about and what Ms. Barrazo looks like thought you agreed and you signed these papers is that you would plead no contest, which means you're not necessarily saying you did it, but you're not contesting it. I understand, and we all understand, that at the time of this offense, there may have been things going on in your life that maybe you don't remember it all correctly or whatever.
There it is, the guilty plea, but notice how calm the judge stays. Even when someone admits guilt in court, it's not drama, it's procedure. Still, you can feel that tension, right? Like the weight of that word guilty.
And I was going to allow that plea of no contest, and then that would be for you to leave your punishment to me. But I can't give you more than 5 years in prison because of that agreement that y'all have made. I could give you 5, I can give you 4, 3, 2, I can consider probation. It'll all depend on some more information that I get when we come back later. So you have to decide today if you want to do that and take that plea, that offer of cap of 5, or if you want to go to trial and let a jury decide.
I want to do what you just said today.
You want to do that today. So then you have to enter a plea to do that of either guilty or no contest. So I'm going to go back over this again, and I'm going to ask you how you plea. And I don't want you, there's no pressure on what to do. I just want you to understand what your options are. So to the offense of aggravated assault that happened on November 4th of 2020, how do you plea? You don't ask me. It's either guilty or no contest or not guilty. Not guilty means a trial. No contest or guilty means we go forward with this agreement.
Move forward.
Okay, so what's your plea?
I'm pleading not guilty.
Okay, so that means you want a trial.
Yes.
You want a jury.
Yes.
And you understand what those consequences could be.
Yes.
And so you don't want to go forward with this cap of 5 years. Well, you don't know what it's going to be today. But what you do know is that it can't be worse than 5 years if you take this deal today. If you go to trial, it could obviously be much worse because it can be anywhere up to the rest of your life in prison. Today, the only thing you know is that it can't be worse than 5. It could be better than 5, but it can't be worse if you take responsibility and say, I'm not contesting this. If you didn't do it, if you think you are completely not guilty, didn't do it, then we'll have a jury trial.
Quick but critical question, citizenship. Why? Because non-citizens can face deportation for criminal convictions. Judges have to make sure the defendant fully understands that risk before proceeding.
Is that what you want to do?
Yes.
All right, we'll get it set for trial.
Okay.
I'll delete the paperwork.
Thank you, Your Honor.
Very much so.
All right. Ms. Peraza will begin preparation for trial. You can go back with the bailiff.
Plot twist: the next defendant, Mr. Wilson, says not guilty after hearing the plea deals and possible sentences. He's rolling the dice for a trial. Bold move or bad strategy? What would you do in his shoes?